Democracy dies behind closed doors. There are times in this country when we find ourselves at a crossroads where the path we choose has the potential to define us as a nation and for generations to come. We've been at a critical juncture since September 11, 2001. How we respond to the atrocities thrust upon us as Americans says everything about who we are, what values we defend, how the world sees us, and how the history that we write will remember us. The manner in which we seek justice against those accused of harming us will determine whether or not the United States will be seen at home and abroad as a nation of laws. We must decide whether we live the values of justice that make us proud to be American, or whether we will forsake those values and continue down a path of arbitrary rules and procedures more befitting those of our enemies. Because we are a great nation, imperfect, yes, but struggling to be true to our founders' vision, we must uphold our core values, even in the toughest times. The right to a speedy trial in court of law before an objective arbiter, the right to due process, the right to rebut the evidence against you, the right not to be tortured or waterboarded or convicted on the basis of hearsay evidence are what truly define America and our commitment to the rule of law and our founders' aspirations. Although the Supreme Court struck down military commissions as unconstitutional and inconsistent with the Geneva Conventions in Hamdan versus Rumsfeld, Congress later passed and President Bush signed into law the Military Commissions Act of 2006, authorizing a modified system of military tribunals that grant the government the authority to prosecute detainees without many of the constitutional protections required by U.S. civilian courts and traditional military courts governed by the Uniform Code of Military Justice. The military commission set up by the Bush administration for the men imprisoned at Guantanamo Bay, including those it suspects were involved in the September 11th attacks, are not true American justice. These trials should represent who we are, what America stands for, and what our commitment to due process is. They are not about how civilized the accused are, but how civilized we are. America does not stand for trials that rely on torture to gain confessions or on secret evidence that the defendant cannot rebut, or on hearsay evidence. For these reasons, the American Civil Liberties Union and the National Association of Criminal Defense Lawyers have taken on the task of assembling defense teams to be available to assist in the representation of those Guantanamo detainees who have been charged under the Military Commissions Act, subject to the detainees' consent. We take this step because we simply cannot stand by and allow the Bush administration's military commissions to make a mockery of our Constitution and our values. We believe in the American justice system despite its imperfections, and we believe we can make the system stronger by engaging it and fighting for what is right, fighting for fair trials and for America's reputation. The prison at Guantanamo Bay and the military commission proceedings set to occur there were set up specifically to evade the American justice system and our rule of law. The proceedings as proposed under the Military Commissions Act and run by the Department of Defense are nothing like the trials guaranteed by our Constitution or long-established military commissions promulgated by the Uniform Code of Military Justice. The Bush administration decided to scrap both time-tested systems of justice. Instead, the administration made up its own rules. The president alone has the power to determine who will be tried by the Guantanamo military commissions. These commissions ignore fundamental tenets of due process and were set up to convict detainees based on secret evidence and that they cannot rebut, hearsay evidence, and confessions that could be based on torture. It is for these reasons that the ACLU and others sued President Bush and won a landmark victory last week at the United States Supreme Court in the case of Boumediene versus Bush that struck down as unconstitutional the Bush administration's suspension of habeas corpus. In a stunning blow to the administration's failed detention policies, the Supreme Court ruled last week that the United States Constitution applies to the government's detention policies at Guantanamo Bay. The court made clear that detainees held at Guantanamo have a right to challenge their detention through habeas corpus. Habeas corpus is the freedom from being thrown into prison illegally with no help, no end in sight, and no due process. Literally, it is Latin for "you have the body." As the ACLU has said all along, no president should ever be given the sole power to call someone an enemy, wave his or her hand, and lock that person away indefinitely. Lieutenant Colonel Stuart Couch is a lawyer and an officer in the United States Marine Corps. He withdrew from the prosecution of Guantanamo Bay detainees because he believed the evidence he was asked to use to prosecute had been obtained through torture and was therefore inadmissible under U.S. and international law. At Guantanamo, the government has been making up the rules all along as it goes along. In America, we do not believe in having fair trials for some defendants, but not for others. The defendants in these proceedings have been charged with horrendous crimes. Any person found guilty of a crime in a legitimate proceeding before a court of law deserves to be punished appropriately. However, it is a central tenet of our system of justice that guilt must only be decided after a fair trial, not beforehand. A defendant's guilt or lack of guilt should be determined in a manner consistent with our Constitution and proper due process protections. A guilty verdict obtained any other way would rob this country and the world of any true sense of justice. There is no reason to make up new rules for these trials. Fairness and due process do not weaken our justice system. They are, in fact, what make it strong. And Americans deserve better than to have these deeply flawed commissions carried out in our names. Up until this month, our lawyers have not had access to the Guantanamo detainees. And then, when they did just 2 weeks ago, it was for less than an hour, and they were kept late for the meeting. We hope to ensure that those prosecuted in the military commission proceedings receive a fair trial and have qualified counsel. As it stands right now, the accused are offered one military JAG lawyer, while the prosecution has well-equipped teams with resources of the entire United States government behind them. We will attempt to assure that the accused are provided with good legal teams, not only to prepare their defense, but critically to challenge the existence and procedures of the Guantanamo military commissions themselves. Words from retired Rear Admiral John D. Hudson seem appropriate. Admiral Hudson spent 28 years in the Navy and served as a Navy JAG from 1997 to 2000. And is the current president and dean of Franklin Pierce Law School. He says, quote, "We could do so much better. As a former Navy judge advocate, I was an early and ardent supporter of the use of military commissions to prosecute our enemies. They could have stood as a shining example to the world for how the United States treats its enemies. Unfortunately, I changed my mind after seeing how they have been conceived. We are now, as a country, seeking to prosecute Guantanamo detainees with military commissions that are regrettably neither appropriate, legal, nor a true definition of American ideas or ideals. I hope my fellow Americans will do as I do in asking the government to grant these detainees fair trials that follow the principles of due process provided in our Constitution. Let's bring this process into the light of day and restore American justice as we know it to be, fair, equal, and for all people." Unquote.